So I just want to start by giving you a very brief overview of who I am and my background, so you understand, what my perspective is on all of this. So I spent my first 7 years practicing law on Wall Street, doing IPOs and fundraising for large publicly traded companies. I then spent 13 years doing the same thing at a mid-sized firm in Chicago, about 100 lawyers. Um, and did that same work, the fundraising work for large privately held businesses at the time. And then in 2010 left, started my own firm with a partner, and at that point really started focusing on the startup world. The laws are the same whether you're raising 500,000 or 500 million. It's just the market terms are very different. And I really liked the prospect of helping founders who are excited, who are bringing something new to the world, and being able to work with smaller businesses. So that's and my firm now it's All Rise Legal Counsel. We have 8 lawyers and 2 paralegals, and we are seed to exit. So we focus on pre-seed, seed, Series A, Series B, fundraising, day-to-day contract work, and then mergers and acquisitions. So if you want to grow by acquisition or get lucky enough to have that big exit, we are there for you. So let's start the presentation. I'm not going to waste time on the overview. We'll jump right in. So when startups are raising capital, they'll often come to me when it's the first raise, and they'll say, so should I go to friends and family, or should I go to one of these angel investors that I've heard about? What's the best route? And like anything else in life, there are benefits and disadvantages to either course. So I'll start with some of those. So with friends and family, the beauty of it is that you've got typically you're the one who is dictating the terms of the investment, because it's just people who want to support you, who want to support what you're doing, and they're pretty unlikely to question the terms of your raise. And that's great versus a serial investor who's much more familiar and is probably going to negotiate the terms and have certain things that they're asking for. On the other hand, with friends and family, you just get the money. And one of the great things about having, a more serial investor is that they usually are investing because they're interested in your business. They want to move it forward, and they're more concerned about the return, and they're more strategic. Usually they'll make all kinds of introductions for you that will be helpful for your business. So those are some of and we're going to have the deck go out, so but I want to just give you an overview right now. So there are other considerations as well, but those are some of the big ones. So early stage companies, again, startups, they'll come to me and say, okay, we want to offer investors a piece of our business, but how do we know how many shares to sell for how much money? For, $100,000 someone wants to give me, what percentage of the company should they get? And there's really no answer, because how can you value a company that doesn't have revenue yet, that isn't profitable yet? And so what started happening was, when I first got into the startup world in about 2010, the predominant choice of an investment vehicle was a convertible promissory note. And that was because that way you don't have to put a valuation on the company at all. What you give your investor in exchange for that $100,000 is you give them a promissory note that says, I'll pay you back in typically 1 to 2 years. I'll pay you interest at typically 7 or 8%. But if before the note matures, we sell the business, or we raise additional capital where we've gotten to a point where there is a valuation on it, X dollars for X shares, then this note will convert to the right to participate in that next round of financing or sale, but on even better terms than the buyer or the new investors are getting, because you took a chance and came in early and invested with us. And so that became very popular. But the issues with convertible notes were there was no form that everybody could agree on. And so they were they were negotiable, very negotiable. And so different investors would say, well, I want this rate of interest, or I want the maturity to be this, and maybe, I want the conversion to be automatic on the next financing, or no, I don't. I want it to be at my discretion. And it was sort of all over the place, which led to legal fees, increased legal fees during the negotiations, and took time. And then the other issue was 1 to 2 years in the life of a startup is a very short period of time. And so inevitably, a lot of these companies couldn't repay the note with interest in only 2 years. And so then you've got the whole, emotional and business issue of we can't pay it back. Do we go under? Do we, do we renegotiate the terms of the note and extend it further? And so all of this really became problematic. And so a group out of Silicon Valley came up with this amazing concept called a SAFE. It's a simple agreement for future equity. That's what it stands for. And you also, there's no need to value the company. And it's a little crazy that investors actually accept these, but they do. They're very, very common now. So instead of giving someone a note that says, I'll pay you back, you just give them this piece of paper that says, when and if we raise another round of, let's say, the preferred stock, so at, X dollars per share, and let's say your next round investor comes in at $10 a share, this piece of paper will convert into your right to get those same shares, but at $8 a share instead. So the typical discount is 20%. And that way you'll get a lot more shares than the new investors, again, because you took the time, you took the chance and came in early. And then sometimes there's also what's called a valuation cap on these, and the same with convertible notes, where let's say your next round is you raise at $100 million valuation. A 20% discount is meaningless to the early round investors. They don't get anything special. So if they're sophisticated, they're going to say, I want to put a cap on the valuation for purposes of conversion. And then the same thing happens at sale. It converts, the piece of paper just converts into common stock, and that's sold as part of the sale, but again, on better terms than the buyer gets. And the beauty of this safe, it solved both problems. So one, there's no expiration. So, you don't have to worry about, oh, I can't repay this. It's not repayable. And two, the terms are really set in stone. So Y Combinator has forms of safe with on its website, and there's with a discount and a cap, with just a cap, with just a discount. And so it eliminates the legal fees and the pain and suffering associated with all that negotiation. So now you've raised as a startup, you've done your safe round or your convertible note round, and now you say, okay, we're ready to raise a few $1,000,000, and we hear all about this, a Series A, and a Series A preferred, which I'll get to in a minute. With a Series A, you give up a real lot of rights associated with running your own company, and so there's this sort of secret, I don't know, hidden hybrid that I love, and it's called Series Seed Convertible Preferred Stock. It's interesting because it's not, and confusing because it's typically the seed round means your convertible note or your safe round. This is a Series Seed, but it's not, it's more of a preferred, it's a preferred stock round, where there is a valuation of the company and you are selling X dollars for X shares. So it's a little confusing, the terminology, but the beauty is, again, there are forms. They're at www.seriesseed.com. And there are only 2 documents involved. So there's an amendment to your certificate of incorporation to authorize the issuance of these new shares. And then there's a purchase agreement. And the holders of that preferred stock, they do get certain rights that a preferred holder gets. They get, if the company is going to pay dividends or is sold, they get their money back before any of the common holders get their money back. So there's a lot of the protections of preferred stock, but at the same time, not giving up anywhere near the rights that you're giving up if you sell a if you actually do a Series A round. And so it's much less expensive from a legal perspective. It's a much simpler document to do, and you're not giving up so many rights in your company. And then there's that, big Series A that everybody talks about. And, this is, supposedly you really hit the big time. You've made it. You're looking at very institutional investors. You're raising, up to $10 million typically. And, I think the caution here that I would give is you're giving up a lot of rights to running your company. So you're first of all, there's something called anti-dilution protection with Series A, which means if you, for some reason, need to raise another round of capital, if you run out of money, and the market's not so good, or you need like just a little bit of extra money, you want to do a bridge round, before, like, let's say, and this has happened to clients of mine on a regular basis, big companies interested in buying us, they're doing due diligence, and we just need a couple $100,000 to get us through, or $1 million to get us through, to closing of the deal. And so we're going to do this, quick bridge round. And typically you're raising at a little bit of a lower valuation at that point to like bring the money on quickly. So if you have to do something like that, the Series A holders get what's called this anti-dilution program protection, where they get to take advantage of that much lower valuation, and they get a lot more shares. So now as founders, you're even more diluted. They also get these protective rights, which the Series Seed holders would get too, but this is much more stringent, where basically they get a vote and a veto over every extraordinary action you'd ever want to take over by your company. So let's say you're the president, and this happens all the time too. You're the president of the company. As a startup, you haven't paid yourself very much salary for all these years. And now you're, chugging along, you're doing great, you're revenue generating, and you want to pay yourself. To give yourself a raise, you need the approval of the Series A holder. To bring on a new executive, approval of the Series A holders. To take on any indebtedness, to sign a lease. I mean, there's really a very long list. And then there's also several other documents. Again, there are forms online at the National Venture Capital Association website has forms. But unlike the 2 agreements for the Series Seed, there are a ton of agreements. There's registration rights agreement. There's a right of first refusal agreement. There are, just endless legal documents. So you're talking about, in terms of legal fees, probably, 4 or 5 times as much. So that's why I love that little hidden Series Seed. So, okay, so you're ready to raise your early stage fundraising round, and you say, okay, so what do I do? You told me about this safe. It's great. I'm just going to print a copy of that safe off Y Combinator, fill in my name, fill in what the discount and the cap are, and give it to my investors, and I'm good, right? And the answer is you are not good, because all of these, what you're doing with any of these, you're selling securities under the federal and state securities laws and that protect investors. And so what the securities laws say are basically, if you are selling equity interests, so some ownership or potential ownership in your business to investors, they're not involved in your business, and they expect you to take that money and turn it into a profit for them, then you're selling a security. And so when you're selling a security, you're required to register with the SEC. Well, you're not going to register with the SEC in a big, IPO and all those filings and all those legal fees. So you need an exemption. The most common exemption that is used from registration that's used by startups is called Section 4A2. And what that basically means in, normal people's terms is that you're not selling to the public. You don't need to, investors don't need protection, because we're not going out there and selling to the public. We're selling to, in a private offering. So what's a private offering mean? Is it, X number of investors? Is it X dollars? Is it, how do you define that? And that became a big issue. And so the SEC came up with what's called Regulation D, as in David. And you'll hear all the time when in the startup world, oh, I'm doing a Reg D offering. So Reg D, really what it means, it's if you comply with one of the rules, and there are a few under Reg D, you will be deemed to be conducting a private offering, not public, and you'll be exempt from having to register with the SEC. So I'm going to talk about the three potential rules that I think most of you as startup founders would be most likely to depend on. So one is Rule 506B, which says you can raise as much money as you want, and there's from investors, and there are really two big things you have to think about. One is you cannot make what's called a general solicitation. You can't go on social media, you can't post on your website, hey, I'm raising money, my company's awesome, come invest in me. You have to have some kind of a pre-existing relationship with all of your investors. And so that can mean, it doesn't have to be your best friend since kindergarten. It can be someone your lawyer knows. It can be someone your accountant knows. It can be a friend of a friend, but it can't be, putting it out there to the world. That's making a public offering. And then the other thing is you can only have up to 35 what's called non-accredited investors. And an accredited investor means someone who has $1 million net worth. And I'm simplifying, but the big ones are either that or has an income of $200,000 for the last 2 years with an expectation of the same this year, or 300,000 with their spouse. So you can only have up to 35 people who don't meet that requirement under 506B. So now you say, okay, I don't know that many people. I don't have that many, to give me the full amount that I need to raise. So now we go to 506C, where you can go out there and say to the world in any way you want. I mean, you can put it on a bench on the road, you can put it on a billboard, you can go on social media, much more likely. And you can raise as much as you want, but all of your investors must be accredited investors, and it's on you to confirm that, not the investor being able to just check a box. So under 506B, you can give them a form and they say, oh, I have $1 million net worth, check, you're good. 506C, it's on you to confirm that. And there are businesses, their website set up where they'll do the confirmation on a private basis for you. So that's 506C. And then the other thing that I get asked a lot of is crowdfunding. And true crowdfunding is allowed again under Reg D, but you have to do it through an SEC registered portal. You can only raise up to $1 million a year. Here you can have all different non-accredited investors, but the amount that they can put in, each one of them is capped based on their income or net worth. So before we talk about this, I just want to do a real quick, okay, great, crowdfunding is the way I'm going. How does that sound? Well, here's the only issue. When you have a large pool of small investors, you're taking on certain risks. So, there's a lot of protections built into the law for minority shareholders, and each one of these people is a minority shareholder and will have the right to inspect your books and records and cause potential problems for you, really be involved in your company. Also, administratively, it's expensive to have this big shareholder base. And then the last thing is, because of those reasons, your later stage, bigger institutional investors like venture capitalists are not real fond of you having a big, a large pool of investors. So just some stuff to keep in mind. So all of these are securities. What does that mean? What that means is that you have to comply with federal and state securities laws. And the ones that the most important laws that you need to comply with are the Securities Exchange Act of 1934 says that you have to tell any investor what a reasonable person would want to know in making a decision as to whether to invest in your company. And so you have to you can't just print out that safe and hand it to your investors. You have to tell them things like, oh, by the way, I have a huge competitor in my space, but we think we're better because of this. You can't leave out that you have that competitor. Anything that a reasonable person would want to know, and I'll tell you how you go about doing that in a second. And actually, let's talk about that. Okay, so what documentation do you need? Do I recommend? The way our firm does it is we give all the investors a subscription agreement, and that's just a, standardized document where the investor signs and says, we understand that we're investing in an early stage company. We can, that we probably won't, we probably won't make money, that the company could fail. We understand that we can't go buying and selling our shares because, or our safes or whatever it is, because this is a private investment. We have had an opportunity to ask the founders all the questions that we have. We've talked to our financial advisors, and we still want to do this. And then I attach two exhibits. So one is a description of the company. You can use your deck, and then usually you have to add a couple things, but otherwise, what's this product? Who's your market? How do you plan on targeting that market and growing your revenue? Who are your management with their bios? How much are they getting paid? And then a cap table and the use of proceeds from the investment. Those are the big ones that go in. And then the exhibit B is the golden ticket, which is the risk factors. And it's anything and everything that could possibly go wrong with this company. And you might be thinking, okay, great, Leslie. So you want me to go to investors and tell them that they're going to lose all their money and that all these, there's all these risks. How am I supposed to bring in investors? And the answer is your pitch deck is to bring in investors. Your subscription agreement, your legal documents, your risk factors, that's your insurance policy. That is there to make sure that if someone does lose their money, they cannot come back and sue you because you've told them this could happen. And they signed something saying, I read that and I knew that could happen. And so they don't have any kind of a lawsuit against you. And I'll tell you, I've been doing this for 33 years and knock wood hard, I've never had, any client be sued because I'm so insistent that there be this set of risk factors associated. All right, let me go back to a couple things on this slide. One is that you might, as a founder, have people come to you and say, I have this big network of high net worth individuals that I can bring to the table. They'll invest in your company, and then you'll pay me like 10% of whatever they invest. Be very, very, very careful before engaging someone like that, because someone who does that for a living is acting as a broker dealer, and they're required to be registered with the SEC. And if they're not registered, you could have aiding and abetting liability. So be super careful about that. There are a lot of nuances to what's a finder and what's okay and what's not, but ask the questions of your lawyer. Second thing is that you need to comply with, when you do a Reg D offering, every state has its own version of the same laws. So you need to file, on the federal basis, you file what's called a Form D with the SEC. Pretty simple form, doesn't give away too much. It's just, who's running your business, how much are you raising, from how many non-accredited investors, that type of thing. And then each state, as I said, has requirements. So like our firm is based in Chicago, the state of Illinois. If you have all accredited investors, you don't have to do anything. If you have any non-accredited, you have to file that same Form D and pay $100 to the state. And that's because you have investors in Illinois. On the other hand, if you have an investor in New York, even one investor, you have to file, and no matter if they're accredited or not, you have to file with the SEC, you have to file with the state of New York, that Form D, and the fees are about $1,200. So, and then the other states are anywhere in between. So where Lauren is in Florida, there's no filing fee at all. There's no filing. So, it's all over the board, but you just got to remember that you have to comply with those rules. So I think I'll just touch on, I have like 3-4 more minutes, so I'll just touch on quickly some issues that I see from a securities lawyer perspective from early stage companies pretty much every day. One is when you're issuing stock to the founders, that venture capitalists like to make, if you're going to go that route where you think you're going to look for venture capital financing, they like to see you issue restricted stock. And that means that it vests over time. And the typical vesting schedule is 25% vests after a year, and then the rest vests in equal monthly installments over the next 36 months. And what vesting means is basically it's yours. You own the stock. You get to vote it. If the company paid dividends, you get them. But if you leave the company, you lose whatever stock isn't vested. And that's why you can see that that incentivizes you to stick around and continue to be part of the company. And it's good if you have a co-founder, because you're, if they're not doing what they're supposed to be doing, you don't want them to have this stock, right? So, and then, but what you have to remember when you have vesting stock is you have to file what's called a Section 83B election with the IRS within 30 days of the date of issuance of the stock. And let me explain. So the way taxes work is when you're issued stock, you have to pay taxes on the value of the stock. Well, when you're a very early stage startup, no big deal. There's no value, there's no tax to pay. But when your stock vests over time, like the venture capitalists like it, the tax regulations say that you pay tax on the value as it vests. So if some of your stock is vesting in 3.5 years, hopefully it's worth a lot of money. You don't want to pay taxes on that. By filing an 83B election, you lock in the value for tax purposes of all the stock on the date of issuance. So it's a huge tax advantage, and it's really important, but you only have 30 days, no exclusions from that to file. So it's very, very important. Another quick thing I'll touch on is if you have a co-founder, you must have an agreement with them talking about, what happens if, God forbid, something happens to one of you, what happens if, as I said, someone's not pulling their weight. And certainly, excuse me, I've been talking so much. Certainly, if you have a 50-50 ownership, you have to have some type of dispute resolution mechanism built into that agreement. And the very last thing I'll say is that the same vesting goes for sure for any advisors or service providers. If you can't pay them cash, which is usually the case with startups, and you want to give them equity, make sure that you do it vesting over time, and also make sure that you have the right to buy back even the vested equity even if you have to pay fair market value in case you part on not good terms. You want to make sure, and that's with a co-founder too, that you always have the right to buy back your equity. And there are legal agreements to cover all that stuff. But I went really fast and said a lot, but I want to give the floor to Lauren, and we'll open it up for questions after. So I'm going to stop my sharing. Okay.
All right. Thank you, Leslie. That was fantastic. I am going to share my screen now. Give me a second. Let's see here. All right, everyone, we're good? You guys can see? Okay. So my name is Lauren Berkeson. I am a trademark and intellectual property attorney in Miami, Florida. My firm is Storylock Legal. And by way of background, I started practicing in 2005 in Miami. I worked for about 7 years at an intellectual property boutique firm, did all kinds of trademark work from clearance and registration to litigation. Then I worked in a more general firm, so I did commercial litigation for a couple of years. Wasn't the biggest fan. Then I clerked for an appellate court judge for about 5 years. Had to pivot a little bit when I had my children, and now I am back into the world of intellectual property law. So we have spent some time talking about investors in your companies. And before you are going to even attract investors, the most important thing is to have your intellectual property portfolio secured. You want your IP to be bulletproof because it's going to make your business more attractive to investors. So One of the first questions that I always get from clients and potential clients is, okay, what is the difference between a trademark, a copyright, and a patent? People will come to me and they'll say, I want to patent my name, or I need to copyright my logo. And let's just, by way of background, make sure that we have all of this information correct. So to make it very easy, we're going to say that a trademark is for your name, a copyright is for your creative work, and a patent is for your invention. So, trademarks. These are your name, they're your names, your slogans, your brand elements that identify the source of a good or service. So, if you're driving down the road and you see the yellow golden arches, you know that you are going to get a burger at McDonald's. If you hear Lululemon, you immediately think, okay, awesome yoga and athleisure wear. So trademarks, whether it's a name, whether it's a slogan like just do it for Nike, these are things that are immediately going to tell you the source of a product or service. So again, trademark is typically your names and your logos, and we'll delve a little deeper into that momentarily. As for copyright, and I'm not going to spend a lot of time on copyrights today, but the most important thing to know about copyright is copyright protection is for your creative works. So if you write a novel, if you write a song, if you record a podcast, those are all creative works. And the moment that your work is, in legalese, it's called affixed to a tangible medium. So the moment you put your novel down on paper, the moment you record your podcast, or your video or your speech or whatever it may be, copyright protection immediately attaches. Now, if you are a new business and you have materials that are like core offerings, say you're a course creator, or say you have a very popular YouTube channel, whatever it may be, if you want extra protection and you want to really bolster your protection, the best thing to do is to get a copyright registration for your work, because it just gives you the right to take action down the road if there is an infringer. But as I said, copyright is for your creative works. And then finally, we have patents, and patents protect your innovations, your technological advancements, your unique product functionality. So as a perfect example, this is my mouse. It's got that ergonomic, what is it called? That ergonomic, hand grip. This is the subject of a patent. There's a utility patent. There's, all kinds of unique inner workings here of this device. So patent, I am not a patent attorney. Most patent attorneys have an engineering background. That is not my background. I am a more creative person, creative attorney. But so patents really are for innovations. So I'm going to talk to you today about your trademark and your name, because that is the foundation of your business. It's the foundation of any business. And without having a strong name and without properly securing your name, you're really putting your entire business at risk. So what is a trademark? As we said, let's think about it in terms of Nike for a second, because they've just done phenomenal things with their IP portfolio. So their trademark, their main umbrella mark is Nike, right? So everybody knows that if you see Nike, you're getting shoes, athletic gear, clothing, whatever it may be. You also have phrases like just do it. You have the logo, which is the Nike swoosh. Nike doesn't necessarily have any other color, sound, symbols, characters associated with it, but you can see that they have a huge intellectual property portfolio. And while Nike might be their house brand, their overarching umbrella brand, they have Air Jordan, Dunks, for all of you, who might be shoe fanatics like my children. They have the Nike Shocks. I mean, there's so many different brands, and they have done a phenomenal job of creating a huge IP portfolio. And one of the things that's important to know is that every trademark registration that a company acquires is a money-making asset of your firm, and it lasts the whole life of your business. So Just a quick tip to know when you have a trademark registration. Other things that you can trademark: colors. So for instance, one of the most famous colors is Tiffany blue. So when you see that little blue box, you don't even have to see the writing on the box to know that if it's, a small blue box that is likely, a gift of jewelry, that box is from Tiffany. Similarly, and I always butcher this name, so forgive me, but the red sole on the bottom of the very, very fancy Christian Louboutin shoes that are, very fashionable, that red sole is a trademark. Interestingly, it is a hotly contested trademark, and in some countries it is protectable, and in others it is not, depending on different rules in each country. But that red sole is a trademark of their brand. Sounds also trademarkable. So for those of you who watch NBC and you hear, forgive my voice, but you hear that dun, 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 that chime sound, that is a registered trademark of NBC. Mickey Mouse as a character, a registered trademark. So there are so many things that you can trademark in your business. And all of these words, phrases, colors, whatever it may be, really help to bolster your brand recognition and make your brand more valuable to potential investors and more attractive to consumers, because when they know and trust your brand, they are going to recommend your brand, they're going to be repeat customers, and so on and so forth. So what? So many people ask me, why do trademarks even matter? If I've already been using my mark, do I need to register it? And I always, always say yes. First and foremost, as I just said, when you have your trademark recognition, when you have your trademark registration and you are able to use the little R symbol with the circle around the R at the end of your mark, you have just made your brand feel so much more authentic and trustworthy to consumers. Now, if you can see from the bottom of my slide, the bottom left, my logo, Storylock Legal, I have the little TM on the right side of the mark. Now, the TM you can use to put the world on notice that you are claiming trademark rights into your name, but you cannot actually use the registered symbol that you see on the screen until you have a federally registered mark. In fact, there are legal consequences for using that mark if you are not actually registered. So when you have that mark, you're building trust with your consumers. You're showing the whole world that you own the mark in the United States. You're putting others on notice that you take your intellectual property seriously. And believe it or not, this symbol alone will deter copycats and infringers. And it also, most importantly, gives you legal leverage. So if somebody is infringing on your mark, or if someone is trying to say that they have rights into the mark, a court will take your trademark registration and view it as presumptive ownership, that you put the burden on the other party that they have to show. If they're saying that they own the mark, they have to show it. If you are saying that another party is infringing on your mark, they have to show that they're not infringing on their mark. So it gives you a lot of recognition and a lot of legal leverage in court. The other thing that people don't realize is that, let's say you have been using a mark for several years and you're very distinct. Let's just say you are, and forgive me because I always use cookies as an example because I'm a cookie fiend. So let's say you have a cookie store and your store is called Clockwork because you are telling customers that every day, like clockwork in the afternoon, you need a sweet treat. We can satisfy your craving that you need at that time. So you're called Clockwork, you make cookies and you are killing it, right? You are opening stores around the country, you're doing great, but you haven't registered your mark. Well, let's say that another company sees your success and they say, all right, I'm going to register a trademark for Clockwork. And instead of writing it as WORK, they do Clockwork, WERK. And they're like, I can do this. Well, guess what? If you haven't registered your mark or applied for your mark, and this infringing company goes to the Patent and Trademark Office, the Patent and Trademark Office isn't going to know that you're there. So the PTO, which is the abbreviation for the Patent and Trademark Office, only looks at what is in their universe. So they're not looking at what use might be made across the country that might have been first or come after you. They're only looking at what's in the PTO. So if you haven't registered your mark, guess what? They might register that clockwork, WERK, for cookies. And then what happens? Then you have to fight to get your mark back. And then you're in a whole legal battle and you're spending so much money that you don't want to spend. So you might be asking yourself, well, if you were clockwork, WORK, and this other party is clockwork, WERK, those are different marks. Well, yes, they are spelled differently, but the PTO looks at marks in any court in the United States based on whether they are likely to confuse consumers. So if you're just talking about clockwork cookies, no one is thinking about how they're spelled, right? So if I say clockwork cookies and someone doesn't have the original clockwork mine in their city, but they have that infringer clockwork with the E, they're not going to realize that it's not the same. So the whole goal of trademark law and trademark registration is to prevent confusion, and just changing the spelling is not enough to minimize that confusion. So those are all the reasons that you want to register your mark as soon as possible. Not only are you creating that recognition and building that trust and deterring infringers, but you're gaining legal leverage and you're making sure that you don't eventually have to fight for your mark because you took too long. So, picking a strong mark. This is always a fun topic. Okay, so when we are in the early stages and where you are right now is like the sweet spot because you are building your businesses, you haven't necessarily, launched big yet, made hundreds of thousands of dollars, but that's where you want to go, right? You want to create as distinct a brand as possible. One of the things that I always hear from clients is, but Lauren, I don't want to, call my cookie company Clockwork because no one is going to know what Clockwork is. So people are going to say, oh, well, I would want to call my cookie company Lauren's Delicious Cookies. Okay, I get it. You want your trademark sometimes to convey what your services are. Or your products, sorry. I especially hear this when it comes to SEO. People say, well, I want to have the type of service or the type of product in my URL, in all of my messaging, because that will drive traffic to my site. And I get it. Yes, there are a lot of other ways that you can drive traffic to your site without having your mark be a descriptive mark. So let's just look at a couple of these brands on here. And there is what we call a trademark spectrum of distinctiveness. So the marks that are not protectable are your generic marks. And then as you move along the spectrum, you have descriptive marks, which sometimes can get some protection, but it's very hard. Typically, the marks have to become famous. Then you have suggestive marks, and then you have fanciful and arbitrary marks. So quickly, a generic mark is basically calling a shoe store shoes. You can't do that. You cannot prevent another company from using the name of the product that they're selling as part of their mark. So if you were going to be Clockwork Cookies, you can't stop anybody else from using cookies, but because the distinctive portion of your brand would be Clockwork. You can get into a bind if your trademark becomes so well known that you run the risk of becoming generic. So aspirin in the States has become a generic term. So you'll see like Bayer aspirin or other different brand names in connection with aspirin, but aspirin alone has lost its protection. Whereas in other countries, aspirin is still a trademark. Another Kleenex is always in jeopardy. Band-Aid, you'll hear, if you hear the commercial, listen to the song the next time you hear it, because now they'll say, I am stuck on Band-Aid brand, so germs don't stick on me. They're putting that brand term into the song because they're trying really hard not to lose their trademark rights. Because if you cut your finger, you're going to ask for a Band-Aid. You're not going to ask for an adhesive bandage. So again, those are the generic marks when they become like just a common name for something. We really don't want that to happen. We want to make our marks more distinct. So we're not going to call our cookie store cookies. But then that leads me to descriptive marks like the Container Store. So you might be wondering, how on earth did the Container Store get a trademark for the Container Store? It's a terrible mark, right? But everyone now knows that the Container Store refers to a particular store. What happens is, if a mark is descriptive, but you've been using it for at least 5 years, and you can show that the mark has acquired distinctiveness and is somewhat famous within the industry, then there is a possibility that the PTO will register your mark. But again, you have to be using the mark for a long time, and you have to be able to show fame. Not an easy battle. And because of that, it is not recommended that you choose a descriptive mark. And I'll touch on that again, as I don't have too much more time because we want to answer questions. So I'm just going to finish this part. But your suggestive marks, these are great. Suggestive marks are afforded a lot of protection. And these are marks that might convey something about your brand, or about your good or your service, but they don't automatically tell you what that good or service is. So as you can see here, Coppertone, which is a type of suntan lotion, it might imply that it's going to leave some kind of copper tone on your skin, but it doesn't really explain what the product is. Think about a Jaguar car. A Jaguar is fast and sleek, but and it gets their name because the Jaguar animal is fast and sleek. That's why the Jaguar car is Jaguar. Another great one that I love for anyone who has ever been on a dating app, the app called Hinge, if you've heard of it. Hinge was named Hinge because the hinge on a door frame connects the door to the frame. So the hinge is the connector of those two components. And in the dating world, the Hinge app is trying to connect two people to put them into a relationship. So suggestive marks are really fun. My mark, Storylock Legal, is a suggestive mark. You kind of like, what does that mean? Storylock. But I always like to say that every trademark conveys a story, and I like to help people lock down their legacies and secure those stories. So that's where I got Storylock from. So finally, the strongest marks that you will see are arbitrary marks and fanciful marks. So your arbitrary mark is going to be something like Apple for computers. Apple has absolutely nothing to do with this technology company, but we all know that when you hear Apple, or when you see that Apple with, a little bite taken out of it, that's related to the computers. And your fanciful terms are your made up terms. So think Pepsi, Xerox, Lululemon. Those are always, always, always going to have the strongest protection. And that's really, really where you want to go. And just to give a small example of the importance of marks and the importance of a distinctive brand, as I might have said in the beginning, I also am a children's book reviewer, and I have a blog, and it's totally random, but the name of my blog is called Happily Ever Elephants. And it doesn't really mean anything, but when my now 11-year-old was a toddler, he would say at the end of every book, and they lived happily ever elephants. No idea where that came from. Yet 10 years ago, when I was starting my blog, I was like, I'm just going to call it Happily Ever Elephants. And if anyone asks why, I'll explain. But it was like my little thing. I loved it. Well, 10 years later, in a world of tons of bloggers and influencers who are, the best kids books, Mommy Loves Books, books for kids, I love Kidlit, Kidlit Mommy, all of these marks that sound the same, no one can tell them apart. No one remembers which of these bloggers, who does what and which is which. But guess what? And not to toot my own horn, but everyone remembers Happily Ever Elephants. And I just got notified from the Patent and Trademark Office that my trademark is on its way to registration. So that was very exciting. So thank you, Leslie. So really, as hard as it is in the beginning, you will have to work harder for sure to create an association between your goods and services and your distinctive mark that doesn't necessarily immediately convey to consumers what it is you're selling. That being said, the payoff for using a distinctive brand and working so hard to build that recognition with your marketing, your advertising, your speaking engagements, whatever it is, the payoff is huge. And when you're looking for investors, the stronger your brand is, the better off you're going to be. So finally, real quick, I will tell you that before you adopt and use your name, I always recommend that you do a comprehensive trademark search. This is going to, I always say it's arguably the most important part of the process when you're naming your company, but it's essentially going to tell you if there's anything else that conflicts with your trademark, potential trademark name in the Patent and Trademark Office. And if there are any marks that are already existing or in use around the United States that are called common law marks, meaning people are actively using these marks in connection with similar goods or services to yours, but they haven't actually taken action to register their mark with the PTO. And the reason that that's important is because you don't want a third party to come after you because they're saying that you're infringing on their mark simply because you didn't know about it. This happens all too often, and I've seen so many companies have to rebrand as a result of getting hit with a cease and desist letter because they didn't do this due diligence in the beginning. So I know, as Leslie said, it was a very quick overview. I have so much more that I can talk about, but that is it for now. And I am happy to answer any questions. I'm going to stop sharing my screen.
Awesome.
There we go.
Awesome. Yeah, I can come in and just talk over these questions that I do see. It looks like the first one is going to be for Leslie. So this one is, are you able to talk to the key differences between reward-based crowdfunding and equity crowdfunding?
Yeah, absolutely. So reward-based crowdfunding is usually through like Kickstarter or one of the platforms like that, and it's not selling securities. So there's no need to comply with federal and state securities laws, and that's when you're basically saying, if you send me money, I will, send you you'll have the first dibs on the product when it comes out, or some kind of promo merchandise kind of thing, instead of asking for your money back with hopefully a profit. So in that case, there's no equity interest in the business, and there's no, you're not selling a security at all, and you don't have to worry about compliance with those laws. And it's actually a great thing to do because it can raise awareness of your product in the public without without having to, go through all the compliance with securities laws or give up part of your company.
Amazing. Thank you so much, Leslie. And we have, looks like some more questions are popping up as well. Oh, actually, let's cover this next one that actually just popped up for you, Leslie. Is the 83B election filed? Oh, is the 83B election filed by the company or each individual recipient of restricted stock?
Great question. It's filed by each individual recipient, but if you're a founder and you're granting equity, and the nice thing to do, and what we do for all of our clients, is when you give them their their restricted stock purchase agreement, have a form of the 83B election attached to it to make it really easy for them and to bring awareness to them, that they should do this.
Nice. Thank you. Then it looks like we got a couple questions for Lauren. The first one being, are there benefits from using a trademark lawyer versus a third-party platform such as LegalZoom?
James, you're talking to a trademark lawyer, so I'm always going to say yes. But in all honesty, I cannot tell you how many people I have come to me as potential clients or who are now clients that started with LegalZoom and their applications were messed up, or they didn't comprehensively search the mark and they just filed because it was cheaper with LegalZoom. And then there's all these problems that we're left to fix. So I will tell you, listen, LegalZoom is a service, right? If you just want to get an application on file, it's cheap, but you are going to pay the consequences potentially of not doing the whole thorough process with a lawyer first. And when I say that, I mean, typically most trademark attorneys who you meet with, whether it's me, whether it's anybody else, they're always, always, always going to tell you, listen, if you pay, you know, $2,500, whatever it is upfront, you are potentially saving yourself thousands upon thousands of dollars down the road. So what happens is a trademark attorney will help you search your mark. They'll file your application in a way that, let's say there is another mark that might have a similar name or even the same name, but is in connection with different services, but there may be some overlap. They're going to help you construct that application in a way that hopefully will minimize any conflict with the examining attorney who looks at your mark. There are a lot of things that working with a lawyer will help you with that you're not going to get that same service with LegalZoom. And I get it, when you're bootstrapped and money is tight in the beginning, it's always the easiest. It sounds the easiest to do things, you know, with LegalZoom or with, you know, do it yourself, which is fine if you want to take that chance. But just know that oftentimes you might end up spending even more money to, you know, respond to an office action because the LegalZoom doesn't search your mark. So you file a mark and there's 3 other conflicting marks out there. Well, listen, now you have to respond to the office action if it's even worth it. You may not get the trademark. And if you've already been using your mark, because the PTO often takes up to a year to respond to you, you may now have to completely rebrand, spend, you know, new money on product packaging, all of your, you know, advertising, marketing, your website. And then you have to create a whole new association between your service with its new name and your consumers. So it's not to scare you. I'm just saying that it's so important because the trademark is the foundation of your business. So it's really important, and it's going to save you as a business owner so much time and so much money if you decide to work with an attorney than it will if you just, you know, go another direction. And not to knock LegalZoom, they have their purpose, right? But if you, I always say that if your business is worth pursuing and worth growing, then it's worth protecting in, you know, as comprehensive a way as possible. So I hope I'll step down from the platform now, from, you know, the soapbox.
Thank you, Lauren. There's actually another question on trademarks. If you filed your trademark yourself and received a notice that your application was abandoned due to failure to respond timely to office action, is there anything I can do to reinstate my application?
Yes. So there is I am blanking right now on whether it's 3 months or 6 months. There is time that you can revive that application, but it is a short amount of time. It's either a 3-month or a 6-month period, and forgive me for blanking on that right now. But so sometimes if you can provide evidence, or, you know, if you have an argument that you just missed the deadline for whatever reason, you can sometimes revive if you're still within that window. But if not, then you'll have to refile if you're past that window.
So, man, it looks like we have 2 more questions. Or there might be another one that popped up, but this one's for Leslie. What can a founder expect to pay as a retainer to engage your services?
So I mean, we usually take about a $1,500 retainer, but then we we bill, you know, we subtract that from our bills. And then if you're not happy, you get whatever's left, you get back. But you know, it might be even a more informational answer to tell you, in general, if you're talking about raising a, like, let's say you're saying, I'm going to raise a safe round, and from day one, what is it going to look like? I usually say you're talking about probably $3,000 between setting up the company and that's not including state filing fees, but forming the entity, divvying up the equity amongst the founders, granting it, setting up a board of directors, all that, and then doing the subscription agreement with the risk factors. It can be more if depending on, but I'm really all about trying to save fees for clients. So the more you can do yourself, like I'll send out a form of subscription agreement and have you take your first shot at it. And and some founders say, that's great, I want to save the money, and others say, for another $1,000, go for it and do it all for me. So there I would say, do not spend more than $5,000 doing a safe round with a lawyer. And I recently had a client who got free $2,500 in free services through an accelerator and then by using a big firm. And they said, I'd rather work with you, but I've got this free legal services already paid for. And I say, like, use that $2,500. But I'm interested in what that buys you. And what they told me, they found out, was it buys you formation of a Delaware C corporation. That for us is literally that would be 1 hour of my paralegal's time at $265.
Oh, wow.
So, yeah.
Wow. Awesome. Well, and it looks like we just have two more questions from Felicia. One is actually for you, Leslie. If I'm looking to do friends and family round, I'm looking to do a family, sorry, I can't talk right now. I'm looking to do a friends and family round. Is it typical to give equity to friends and family in this round when your valuation is so low?
I would do a safe or a convertible note. I think that's the way to go. It will, then you don't have to put the valuation on the company, and you don't have to worry about giving up too much of your company for too little money because the valuation is so low.
Awesome. Thank you. And the last question is for Lauren. I have a brand name and I've been using for the last 4 weeks in a public way, and I broadcasted the name and published it on the internet in a professional presentation and document. Oh, and in a professional presentations and documentation. We have been using the name with the TM at the end. Does all of this protect my trademark until I am able to do it officially? I checked the USPOT search before we started using the name.
Okay, so this is an interesting question. If Felicia, I'm curious as to whether you are offering a product or services. If you want to drop that in to the chat, feel free. Essentially, you are not actually, trademark rights don't actually accrue until products and services. Okay. Until you are actually using the goods in interstate commerce. So what that means is, if you are a product, until you are selling those goods across state lines, until you've made that first sale, or even let's say you're transporting goods from one state to another, you will not have trademark use. So just having a domain name or a social media handle or talking about your name or putting in a presentation does not give you trademark rights. Now, for services, it's a little different. Obviously, you can't necessarily like transport a service across state lines, but if you have a website up and you are offering services, then that is considered trademark use. So does this protect your trademark? Nothing really protects your trademark until you file an application and get that registration in hand. And again, so I know you said that you checked it on the PTO, so it seemed open. I don't know what kind of other searching you did, but until you have, unfortunately, a registration in hand and have really done a thorough, comprehensive search of what else is out there, it's hard to say that you're protected. But if you've started, trademark rights in the United States are based on your first use of the mark. So if you have started using the mark, let's say you started using it and made your first sale today on April 23rd, you will have prior use and first use over anyone who starts using a similar mark that comes after you. So essentially you're protected against these subsequent users. But if there was anybody that came before you, then you are kind of out of luck, and just registering a domain name or having a social media handle doesn't actually give you trademark rights. So I'm glad that you've made a sale that will help you. So now you have actually been using your trademark in commerce, and now you will have protection. But really you don't have like your legal protection until you have that registered trademark in hand. Does that help answer your question? I hope.